Hello, everyone, and good afternoon. Welcome to the first webinar in our Construction and Engineering Foundations Autumn 2023 series on payment in the construction industry. Thank you for joining us today. My name is Martino Giaquinto, and I'm a partner with the privilege of leading M&R's construction disputes practice, and I shall be your host for today's talk. But the real work is being done by two of our busy and experienced construction lawyers within the team. So let me introduce you to our speakers, being Ed Freeman and Patrick Wisheu. Ed is a senior principal associate in our commercial construction team, having 20 years of specialist experience in the field. He has particular expertise in drafting complex transactions in various subsectors within the construction industry, and is very familiar with all the major construction forms, including JCT, NEC, FIDIC, MF1, IChemE. Ed is recognised in the legal directories, with this year's Legal 500 noting him as a rising star, and clients saying Ed somehow knows how to calm us when we are concerned. My team rely on Ed so much, a skill I value above all else. Whenever Ed is instructed, I know that I will receive sensible, clear, articulate, and commercial advice in a timely manner. He's a pleasure to work with. Patrick is also a principal associate in our commercial construction team, having trained and qualified with us over 10 years ago. Patrick is an experienced construction disputes lawyer, familiar in advising on many of the standard form contracts, including JCT and NEC, as well as being versed in representing clients in complex and high-value disputes in litigation, arbitration, adjudication, and mediation. Patrick is also recognised in this year's Legal 500 as a key lawyer, with clients saying he has an amazing ability to delve into the most technical aspects of complex disputes, and he really grasps the details of the cases. So the topic of payment and when an entitlement to payment arises is, perhaps surprisingly, more complex than one might ordinarily think. At common law, the right to payment is, if it's an entire contract, arises on completion of the works. And in that circumstance, the contractor is not entitled to interim payments. However, in modern construction contracts, the financial relationship between the parties and the entitlement to interim and final payment is regulated by statutory provisions or contractual terms, or a combination of the two. Over the next 40 or so minutes, Ed and Patrick will consider the various aspects of payment, looking at the essential requirements set by statute and, if more restrictive, contract terms. Our speakers will canter or gallop through the complexities around payment as required by the Housing Grounds Construction and Regeneration Act as amended, and the JCT Design and Build 2016 form. This will then be followed by a Q&A session. So feel free to submit any questions you have during the session into the Q&A box on your screen. A recording of the session is taking place, and I understand this will be sent to you afterwards, along with a copy of the slides. So, with those few introductory words, let's make a start, and I'll hand over to Ed. Thanks very much. Ed.
Thank you, Martino. As Martino said, I'm going to be talking largely about the Housing Grants Construction and Regeneration Act 1996, as amended by the Local Democracy, Economic Development and Construction Act 2009. I think the talk's already long enough as it is, so I'm going to shorten it to just talking about the Act, or the Construction Act. And as Martino said, it's really a restriction on freedom of contract with regard to payment. It also has aspects in relation to dispute resolution as well, and adjudication, but that's not the subject of today's talk. It applies to construction contracts. Construction contracts are defined by the Act as clarified by subsequent court cases. Again, that could take another training session to discuss, but for the purposes of this talk, we're going to assume there was a construction contract in the UK, with none of the exceptions applying. So there is some flexibility on what parties can agree with regard to payment, but within some strict rules. For example, you can choose payment periods, which may seem perhaps the most obvious thing to clamp down on. But and the payment provisions broadly fall within sections 109 to 117 of the Construction Act, if you're inclined to read it. And it's important to sort of mention at the outset some of the consequences of failing to comply with the payment provisions. As we'll come to see in a second, you can have terms imposed upon you if you don't put in the relevant bits. You may end up with suspension of works if you are the payor. You may end up with or services being suspended. And you may end up with what's colloquially called a smash and grab adjudication, which I'm sure Martino would be happy to talk about. But I was going to say something about what the scheme is. So I mentioned the scheme. The scheme for construction contracts, England and Wales regulations, is a set of regulations produced under the Act, and it's effectively a set of payment terms, almost ready to be implied into your contract if you don't include the relevant provisions from the Act. So if you don't include payment provisions in the contract at all, the payment provisions in the scheme will apply in their entirety. And if part of your payment provisions in your contract fall foul of the requirements of the Construction Act, then that part will be replaced by the relevant payment provisions in the scheme, i.e. it'll replace it on a piecemeal basis. The Act states that every party under a construction contract is entitled to payment by instalments, stage payments, or other periodic payments for any work under the contract, provided the duration of the contract is 45 days or more. And it goes on to say that every construction contract shall provide an adequate mechanism for determining what payments become due under the contract and when, and provide a final date for payment in relation to any sum which becomes due. As I said before, the parties are free to agree the time between the date on which a sum becomes due and the final payment. There's a couple of important terms which have come out of that previous description. One is when payments become due, often referred to as the due date, although the word due date is not actually used in the Construction Act. And the other one is final date for payment. I put a quote there for what's the difference in theory by an example given by Lord Neuberger. But in reality, for most people, the due date is when the clock starts ticking for the purposes of the payment provisions under the Construction Act. And the final date for payment is effectively the actual date when the money needs to change hands. There are three main possible notices which can occur under the Act, which fall between the due date and the final date for payment. So the first one is a payment notice. Then you've got a default payment notice, which I'll come on to a second, and a pay less notice. In terms of the payment notice, the Act requires that a construction contract shall require the payer or a specified person, which could be, for example, a contract administrator, to give the payee notice not later than 5 days after the payment due date. The 5-day period cannot be altered. A payment notice is compliant if it specifies the sum that the payer considers to be due at the payment due date in respect to that payment and the basis on which that sum is calculated. Well, what if it's not validly given? If that notice is not given, then effectively, if there has been if the contract permits the payee before the payment notice is given to effectively specify to give an application for payment which complies with the requirements of the Act, then that application for payment will become a default payment notice. If the contract doesn't provide for that, then the payee can submit its own default payment notice. So why are these notices important? Well, the notices effectively established what's called the notified sum It will be the amount specified in a valid payment notice given by the payer, or if not, it will be the amount specified in a valid default payment notice. And effectively, there's an obligation to pay the notified sum by the final date for payment, with significant consequences for non-payment of that notified sum, including suspension of performance or the possibility, as said before, of a smash and grab adjudication. And there are very limited exceptions to that. Perhaps the key exception is the provision for the payer to serve a notice to pay less than notified sum, or pay less notice. This pay less notice must state the sum considered to be due on the date the pay less notice is served and the base on which that sum is calculated. The observant amongst you will note that effectively these are the same requirements as for a payment notice. They didn't used to be. Under the Act previously, before it was amended, we had withholding notices, which had a different requirement. But now the two are largely aligned, which is helpful for the purposes of the case law on this. There is, of course, a deadline for serving a pay less notice, which is helpfully stated as no later than the prescribed period before the final date for payment. This prescribed period is whatever you've put in your contract, or if you haven't put something in the contract, then it's going to be the period set out in the scheme. So that's a good example of the scheme imposing a provision if you haven't decided upon it yourself. And the scheme provides that this notice must be given 5 days prior to the final date for payment. Another exception is insolvency. There is a provision that if the payee becomes insolvent after the date for giving the pay less notice, then that is an exception to having to pay the notified sum as well. But bear in mind that if this happens before insolvency, then you still need to serve the pay less notice. So I'm going to do a little bit of some practical thoughts now. It's perhaps unsurprising, given the draconian nature of the Construction Act provisions, that there's been a lot of case law surrounding its implementation and use. And I'm going to try and draw out some themes, first in terms of drafting, and secondly in relation to the all-important payment and pay less notices. As Patrick will talk about later, the standard form contracts have included what should be Act-compliant wording in them, and with limited exceptions, such as changing the payment periods, great care and I would suggest some advice should be sought before playing around with payment wording. Nevertheless, there are some headlines. I think the first one is probably to include that, if you are the payor, to include that insolvency wording I've mentioned earlier, so that you can utilize the ability to withhold payment if after the pay less notice date the payee goes insolvent. Second thing, big headline point, everyone knows pay when paid clauses are outlawed and have been since the introduction of the Act, and with limited exceptions, pay when certified clauses as well. So clauses which say we're not going to pay you unless we've already been paid further up the chain are not going to fly under the Act. I think the next thing is close attention must be paid to the Act when drafting. An example is in relation to the calculation of the final date for payment. It became common and perfectly understandable practice for the payer to make the final date for payment subject to, for example, the submission of a VAT invoice. The problem is, however sensible that may seem, the courts have noted that the Act says that the contract shall provide for a final date for payment in relation to any sum due, and have interpreted it to mean that the only discretion in relation to the final date for payment is the length of time between it and the due date. So you can extend the period between the due date and the final date for payment, but you can't put preconditions in between the two. There's more flexibility in relation to the due date, becoming due subject to a notice from the becoming more flexibility in relation to the due date, but care still needs to be taken, for example, not to make the due date subject to a unilateral notice from the paying party. And finally, you can, as I said, you can adjust payment periods, and the pay less notice periods, but people may need to be aware of codes of practice which they've signed up to, so that they don't move out of step with what the market considers is reasonable, aside from the Act. And you also need to make sure that the periods work as well, especially when people shorten the payment periods and leave the pay less notice periods intact. That can cause some practical issues. Just to reiterate, you need to have an adequate mechanism. So it's important to think through whether or not whether payment clause objectively makes sense, and whether it does what you want it to do. I mean, the courts are likely to take a pragmatic approach if they feel that they can. It's going to be taken so far. You probably don't want to find yourself, if you're a contractor or a consultant, in the position of Grove and Balfour Beatty when the payment schedule ran out, and with it the ability to get interim payments. So drafting payment and pay less notices, again, there's some flexibility in form. The courts will look more at the content, in particular the amount due on the basis of which it's been calculated. So substance is more important than form. And although this is not by means a sales pitch for the RICS, I understand that template forms are available. And as you can see, there's a quote from Coulson about how the courts will take a pragmatic approach. There is no need to state pay less notice or payment notice, but there doesn't seem to be a particular reason why not to do so. But the important thing is you need to comply with the requirements of the Act. So substance is the most important thing. Payment notice must be sufficiently clear and unambiguous, inform substance intention, so that parties have proper notice of the sum assessed as due and the basis of that calculation. There are some limits on flexibility and clarity. It's worth noting that a notice that has a draconian effect, such as a final account notice, must make it clear the clause of the contract that it's been issued under. And so if the notice is having a much more significant effect, then that's likely to be the case. And intention and belief in the amount due is important. It's no point just making a figure up and hoping that will suffice for the purposes of a payment notice or a pay less notice. It's got to be something that you can genuinely consider to be due. A couple of final notes. Payment notices must relate to individual payment cycles. Pay less notices must be clear as to which notice they're responding to. I'm going to make a couple of final comments here. You can't just serve a holding payment notice to gain time to assess the sum due, and you can't serve a pay less notice before the time for service of a payment notice for the default payment notice has expired. The Downs case is actually quite a nice example of what happens when people try to work around the Act. The employer had got into the habit of issuing 97p payment notices within the time period under the Act, and then issuing a more substantive one afterwards. In this case, a payment notice payment notice 34 for 97 pence was then followed up by another one called 34A for over £600,000. Perhaps understandably, the court decided that it cannot realistically be contended that the payment notice 34 accurately stated the sum which the employer considered to be due. So unsurprisingly, the 97p payment notice was held to be invalid, and unfortunately 34A was out of time. So I think the message from me, and I suspect Patrick will probably follow up on this, is that parties need to give themselves enough time to do things properly. It's often the rushed payment notice or the rushed pay less notice that really causes people problems and ends up in parties appearing in adjudication or court. So on that note, I'll hand over to Patrick.
Well, thank you very much. Thank you very much, Ed. So plenty of complexity in relation to that payment regime and some helpful hints and tips from you. So thank you very much. So as you say, delighted to welcome Patrick. Patrick is going to talk about a modern standard form contract. So Patrick, over to you.
Thanks, Martino. And thanks, Ed, for running through what the statutory approach to payment in the construction industry is. So what I'm going to do is I'm going to work through kind of the process and procedure that needs to be followed under one of the common standard form contracts that we see being used, being, for the purposes of today, the JCT DNB 2016, but in its unamended form. So if you are making any amendments to that, what I'm about to say won't necessarily all follow. But as Ed said, do think carefully about how any amendments to the payment mechanisms are made. What I'm going to do is I'm going to work through what the interim payment mechanism is and the process that needs to be followed, and then also some kind of notice requirements under the JCT itself. Ed has kind of touched on some common law and in statute, and in that regard, I'm going to talk about it kind of in form and in respective time as well. Of course, if you're using any of the other standard forms, they will also, if they apply to English construction contracts, will need to also grapple with the statutory requirements as well. So starting with the interim payment application, the interim payment mechanism, that applies throughout the entire life of the project from the first interim valuation date all the way through beyond the PC until the due date for final payment. And the same mechanism applies irrespective of whether or not the parties have agreed to payment in stages or on a periodic basis. And when you look at what the interim payment mechanism itself is, I've broken this down into kind of 5 key areas. So this is starting with the interim valuation date, then moving on to the interim payment application, the payment notice, an optional pay less notice, and then finally payment itself. So just harking back to what Ed was talking about under the Act, you can see how the interim payment application, the payment notice, and the pay less notice all have their equivalents in the statutory regime, because what the JCT is seeking to do is to be compliant with the Act. And so a lot of the language that I'm going to be talking about is very reminiscent of what Ed has ran through already. So the one that isn't quite what it says on the tin in respect of under the Construction Act is the interim payment notice, interim payment application, which is made by the contractor, which would be the default payment notice under the Act. The payment notice and the pay less notice are what they say they are. So starting at the beginning, I'm going to just try to, for each of these, give you a short what, when, and why for each of the steps as we go through this. So you start at the very beginning with the interim valuation date. Under the contract, that is a date stated in the contract particulars. But if one isn't filled into that blank in the particulars, then the JCT makes the first interim valuation date be 1 month after the date of possession. All future interim valuation dates take place on the same date in each subsequent month up until final payment. But if it falls on a weekend or a non-business day, it goes to the next nearest business day. It doesn't go to the next one, it goes to the nearest one, so it could go before. So the interim valuation date is important because it sets the earliest that due date that Ed was talking about earlier could be on each interim payment cycle. The interim payment application is the next stage, and it is the contractor saying to the employer what it considers due at each due date and the basis on which it is calculating that. So as Ed was saying, these all need to be saying what needs to be paid and the basis for what that calculation is. It's important to note that in the JCT, the employer's requirements may require there being further supporting information appended to the interim payment application. And if that is not given, then that could make the interim payment application invalid or be given incorrectly. So that's what it is. Why is it important? I think relatively self-evident. It is the contractor saying what it considers due. So if it isn't given, then there is no default amount to be paid if a payment notice or a pay less notice are given later and given incorrectly. As to timings as to when an interim payment application is to be made, the JCT envisages it being made around the time of the interim valuation date, but it doesn't prescribe precisely how early or how late it can be made. But what it does do is it sets and crystallizes what the due date is for that that payment cycle. So the interim valuation date is the earliest date that it could be, but if the interim payment application is made after the interim valuation date, then the due date is 7 days from when the interim payment application itself was made. If it was made on or before, then it is 7 days from the interim valuation date. So whilst the JCT doesn't actually expressly say how early or too late it can be, you should probably exercise some caution if you're going to be wanting to make an interim payment application very early or very late, because the courts have on previous JCT forms put in an implied obligation on the contractor that it makes its application within a reasonable period of time. And in that case, that was just a matter of days from the relevant trigger date. So the next stage is the payment notice. This is the employer's kind of first chance to respond to the contractor's payment application. And it's a notice given under the JCT, so that'll have its own form requirements, which I'll get to later. And it needs to be stating on its face, one, what the employer considers to be due at the due date, and two, the basis on which that sum was calculated. There are some more nuanced points on this, one of which Ed has already touched on, is that consideration by the employer has to be a genuine consideration. So like Ed said, it can't just be 97p and hoping that that's enough. So not only does it need to be genuinely held, it also needs to be calculated in a prescribed manner under the JCT, and that prescribed manner is based upon whether or not it's stage payments or periodic payments, and it needs to be calculated in accordance with clause 412 or 413 respectively. And then there's amounts to be withheld from that calculated amount under 414, which includes amounts already paid and retentions in broad terms. So why is the payment notice important? Like I said, it's the employer's first chance at saying what it considers due, and it itself sets what will be the amount due at the final date for payment, subject to any pay less notice that is validly given. And so it does that by either being given correctly, and in which case the amount stated becomes the notified sum that Ed talked about earlier, or if it's given incorrectly, it doesn't act as that, or if there is none given, it doesn't act as that, and the amount to be paid at the final date for payment is the amount applied for in the interim payment application. As for timings for when the payment notice needs to be given, thankfully the JCT is clearer than it is in respect of the interim payment application, and it needs to be, and this uses similar language as seen in the Act, it must be given not later than 5 days after the due date, with the due date, remember, being set by the interim payment application in relation to when it is given vis-a-vis the interim valuation date. So I said that was the first chance that the employer gets. There is a kind of safety net, a second bite at the cherry that the employer gets in the interim payment cycle. There's nuance when you get to the final payment cycle in that it's the payor who gives this and not necessarily the employer. This is the pay less notice, and it's a notice given by the employer in the interim payment cycle where it intends to pay less than the notified sum. So that's either the amount stated in a payment notice, or if one wasn't given, or if the employer thinks that it was given incorrectly, the sum stated in the interim payment application. As with the other kind of payment documents that need to be given, it also needs to state the amount that is considered due, and also the basis for calculating such sum. What's important to note, though, with the pay less notice, that the kind of date by which it is saying that amounts are due isn't the due date, it's the date of the pay less notice itself. So that makes why the pay less notice is important a bit bigger. So it's not only is it the second bite at the cherry, allowing the employer to try to rectify some error or omission in its payment notice, but it also lets the employer take account of matters that may have arisen post due date and pre date of the pay less notice. So for example, if the project is in delay and it's so far gone that all the notices have been given in respect of LDs, then the LDs could be calculated and deducted under the pay less notice up until the date of the pay less notice, and not just up to the date of the due date. So what it does is if it is correctly given, is it sets a reduced amount to be paid on the final date for payment, then the notified sum. And as for timings for the pay less notice, again, this harks back to what Ed was saying in respect of timing, but it must be served no later than 5 days before the final date for payment. And in the unamended form of the JCT, the final date for payment is 14 days from the due date, which again is set by when the interim payment application is given. So turning to the last stage in this, the payment itself, this needs to take place by the final date for payment. It needs to be done in full of the amount either stated in the pay less notice or the notified sum from the payment notice or the pay less notice. But the payment notice or the interim payment application. An easy way to kind of think through which amount is to be paid is which of the pay less notice, payment notice, or the interim payment application were the last in time correctly and validly made in that order. If then, as I've already outlined, the when for the payment is 14 days from the due date. And what happens, why is this important that it's met? If payment is not made in time or in full, and that includes payment of any VAT that's applicable to the payment, it's the consequences that Ed has already touched on, but it's spelled out in the JCT. First of all, there's interest that runs at a simple rate based on the interest rate, which is 5% above the base rate of the Bank of England at the time of the payment becoming overdue. And also, probably more critically, the contractor becomes entitled to give a notice that it intends to suspend its works. And if that if that non-payment continues for 7 days, then the contractor can suspend its works. And also, as part of that, it becomes entitled to pay additional payment of its reasonable costs reasonably incurred in respect of that suspension. So not only is the employer facing having to pay the principal amount, interest on that amount, it may also be facing additional payment associated with any suspension of work, noting that those additional payments are kind of subject to a double reasonableness test, that they may be reasonable in amount and reasonably incurred. So I've talked quite a lot about things being done correctly or validly. So I'm going to give some color as to what valid and correct mean. Ed has already talked quite a bit about what the court has said and what statute says. So what I'm going to do is I'm going to talk about what the JCT itself says. So starting with kind of form requirements, under the JCT, the interim payment application may require additional further supporting information in the employer's requirements. So make sure that that is checked and complied with, because if that isn't, then there could be an argument that the interim payment application isn't validly made. All three of the interim payment application, payment notice and pay less notice, need to set out the basis on which they are stated and the basis on which that is calculated. As I've said, for the payment notice and probably also for pay less notices, that consideration of what is thought to be due needs to be a genuine consideration. And also, the notices, the documents themselves, have to be issued to the right person and to the right address and in the right way. So the JCT sees two ways broadly in which this is done. Either the parties agree amongst themselves in writing a kind of communications protocol by which they agree how notices and other communications are given, to whom and in what form. The JCT expressly envisages that could include electronically, so email can be enough, but it does need to be agreed in writing previously between the parties. If the parties don't have, or if they haven't agreed any kind of communications protocol, as I've dubbed it, the notices and communications will need to be given by hand or by prepaid post to either the date, the address stated in the contract particulars, or to the, if that address is no longer current, to their registered office of their company or their last principal place of business. There's a few more kind of good practice points that I'd probably suggest at this point. If you're going to, in any construction contract, really, you should probably be looking to agree some form of communications protocol. But if you are going to be agreeing in that email is sufficient, then whenever you're clicking send on any important communication or on any notices, then you choose those boxes in Outlook to also put on a delivery receipt and a read receipt. So then you get a notification that it's kind of left your server and hit their server. It's probably good practice, but not necessarily, as Ed was saying, a strict requirement for the notices to say on their face what they are and refer to which provisions they're made under, particularly if they're going to have some draconian consequences. The notices can base, there's been case law to suggest that the notices can base their calculations on calculations found in other documents. But if you're going to do that, be really clear in which those documents those are, and ideally just append those documents to the notice itself, so there can be no question as to where that calculation is made. And also, just in respect to pay less notices, Ed touched on this, but there's been a recent case where it's been held that any pay less notice needs to be clear as to which interim payment application or payment notice it is responding to. And then turning to the matter of time, the JCT has some express deadlines for the payment notice and the pay less notice, and these are respectively not later than 5 days after the due date for the payment notice and not later than 5 days before final date for payment in respect of the pay less notice. But how do you calculate, how do you actually count these days? Well, the JCT does have some help on this. If you're counting forward on days, then you start counting on the day after that event. So for the payment notice, you don't start on the due date, you start the next day. And I'll give you two examples after this as well to hopefully make this a bit clearer. And then when you're counting these days, you count weekends, but you do not count public holidays. And like I said earlier, in respect of the interim payment application, there is no deadline by which that needs to be given. It's a bit vague about that, but proceed with caution if you're going to be making that very early or very late. And in respect of the timing of when these documents are actually received, unhelpfully, the JCT doesn't have a deeming provision for when payment notices and pay less notices for the purposes of interim payment are actually deemed received, like you see in a lot of contracts. So you're actually going to have to just rely on when these documents were actually received. It's important to note, though, that that's not when somebody picks it up and reads it, it's when it's actually received. So if you're doing it by email, probably sensible to have a delivery receipt or something like that, so you know that it's hit their server. It doesn't mean that they have to have read it. It just needs to have hit their server. And if you're having something delivered by hand or by post, sensible to keep a record of when it was delivered. So if you're sending it by post, special delivery where you get a nice little signature saying it was received by this person on this day at this time at the address is useful evidence for that. And then just to give you two quick examples of the kind of counting of days. So just set out a high level example. If the due date is on the 1st, which is a Tuesday, then counting 5 days forward, you start counting on the Wednesday, and the payment notice needs to be given no later than the Sunday. The final date for payment is 14 days after the due date, so that turns into Tuesday the 15th. And then the pay less notice is not later than 5 days before that, so you count backwards 5 days, and you get the pay less notice needing to be served by Thursday the 10th. When it comes to the time on those days, there's also been a recent case where it's been confirmed that it doesn't matter what time on that day. A day in English law is the full cycle, midnight to midnight. So just because it's served at 5:05, that doesn't mean that it's invalid as long as it's still received on that day. There may be amendments to a contract that may try to make it clear that it needs to be served by a certain time, but in the unamended JCT, that language isn't there. So comparing these dates to if you have a public holiday, so let's put a public holiday on Monday the 7th. What you'll see there is the due date remains the same, the payment notice remains the same because there's no public holiday in there, but the final date for payment is pushed out a day by that public holiday, and the pay less notice, because you're counting backwards, moves forward a day as well, but it's still 5 days before the final date for payment. So I've had a quick canter through of the process and the procedure that needs to be followed in the JCT, but you might be wondering, well, this is just some pieces of paper. Why does this matter? I hope I've explained why each of these are important, but I've just set out here in quite brief terms what the consequences are if you get these things wrong. So if the interim payment application isn't made, or if it's made incorrectly, then there's no default amount to be paid if no payment notice or pay less notice is issued against it. If a payment notice is made incorrectly, then the employer will have to pay the amount applied for in a valid interim payment application, subject, of course, to a pay less notice, which, if that is given incorrectly, will mean that the employer needs to pay the notified sum, being the amount stated in a valid payment notice or the interim payment application, if not made. And finally, if you don't make payment in full or on time, then the employer will be liable to pay interest. And also there's a risk that the contractor may seek to suspend the works.
Well, thank you very much, Patrick. Indeed, a ton of complication, a ton of complexity, both set out by way of the statutory provisions and then seemingly amplified, at least by virtue of that standard form. So, got a few questions here, it seems. So this one seems to be derived from maybe a smash and grab experience. So the question is this, what, if anything, can an employer or payer do if it fails to serve a payment notice or a pay less notice following receipt of an interim payment application? Is the notified sum in the interim payment application in those circumstances automatically payable? So that one, it seems, Patrick, is probably for you.
Yeah.
Because you just kind of touched upon it. So what's the answer?
Yeah, so kind of on its face of that question, an application for payments being made and then there's been no payment notice or pay less notice against it. So on its face, it would appear that you have to pay the amount applied for. But what you do then is you look and you investigate whether or not there's anything that you can do to challenge the validity of that payment application. So was it given in time? Does it meet the requirements of the written terms of the contract? So in the JCT, does it state the amount due and the basis on which it's calculated? Were there any further supporting information required by it under the ERs? Or if you're just looking at statute, you might just be more limited to, does it state the amount considered due and does it have the basis on which that's calculated? So it's not all without hope in that situation, but on its face, you have to pay the amount applied for, but you might be able to attack and undo the payment application itself.
Okay, thank you. So I think the simple takeaway is try not to get involved. Be involved in that situation. Serve your payment notice or your pay less notice to avoid having to attack or try and undermine the application for payment. Okay, thank you. Another question here. So this one is, if the parties have agreed to a schedule of interim payments up to the project's planned completion date, but for some reason the project is extended and therefore the contractor is still on site post this period, does the contractor have an entitlement to further payments after the last scheduled payment date? So Ed, do you want to have a go at addressing that one, please? You're on mute there, Ed.
Sorry about that, Martin. Yeah, it sounds quite similar to Grove and Balfour Beatty case on its face. I think all of these things you have to look at the specific circumstances. I think it's quite similar to what Patrick was saying about the application point is not to immediately panic, I suppose, in that situation, whichever side you're looking at, and actually look at the contract, which in some detail, which I know is a speciality of of Patrick and Martino. So I think in those situations, you looked at the contract and see whether there's potentially a way out. I think there was a Court of Appeal case fairly recently where they managed to find a way through that. There was a payment schedule, but when on closer inspection of the actual contract, there was a bit of ambiguity in that it said not only was a payment schedule it had to be complied with, but there was also a clause which said if you don't provide your application by a certain date, then it will be invalid. And the two didn't quite match up, and the second was slightly more favourable. And although arguably in relation to the first, in relation to the table, they were out of time, on relation to the second provision, they were within time, and the court construed it so that the second provision actually applied, and therefore it was okay in terms of the timing of the application. So I think the answer is to look very carefully at the contract, and it sounds like a lawyer's get out clause, but always look carefully at the facts and apply the facts and the contract and the circumstances.
Yeah, okay, thanks, Ed. Yeah, certainly from my experience, I think the direction of travel is clear from the courts that if, for instance, the parties have set out a schedule of payments and with certain applications and certain payments pinned to set dates, then the courts will give effect to the terms of that agreement. And yeah, in that Grove Developments and Balfour Beatty case, as you mentioned, that meant that the contractor in that case wasn't entitled to any interim payments post that date, even though work was being done. Yeah, no implied term. But as you say, yes, there is that recent case. I think J&B Hopkins, I think, and Building Solutions, A&B Building Solutions, I think, whereby the court looked at the terms closely and scrutinised it, but found some flexibility in the schedule. So okay, well, looking for any more. Can't see any.
There's an anonymous question about what do you do if a contractor issues an interim valuation after the set due date, day 5 after, under a JCT? Does the contract administrator still have to issue a valuation certificate within the 5 days from the set due date? That of course depends on the terms of the precise JCT that you're using, but assuming that we're talking the JCT D&B 2016, which I've talked about today, you would still have to respond to that valuation, that payment application, even though it's 5 days after the original due date, which would be the interim valuation date. But the interim payment application, this interim valuation being applied for, would actually push the due date for that cycle back 5 days, because it'll then be 7 days from the interim payment application being made. And so then it's 5 days from that extended, that crystallized due date, rather than the previous one, because otherwise you'd be all of a sudden having to value something the day it's received.
Thank you, Patrick. Thank you. So I can't see any more questions. I don't know whether your feed is showing you any more.
I have a few more here, and I don't know, Ed, if you want to answer this one. I don't know if you've seen it, but how do you recommend building in public sector 30-day payment terms from receipt of invoice?
It's maybe a tricky one. We'll have to take offline and answer after that one, I think, to be honest. Yeah, I think that's probably one we'll have to take offline. Patrick can deal with afterwards. I think on that one might be too contentious for the purpose of this talk.
Okay. Well, certainly we don't want this talk to be contentious. We intend it to be solution focused. But look, well then let me wrap up then. That then will conclude our questions, and certainly keen to finish within our allotted time frame. Our next foundations webinar is on the 9th of November and is titled Top 10 Tips for Managing Your Construction Contract. So we look forward to seeing you all again soon. We'd also like to plug our construction and engineering blog, Practical Completion, which is a useful repository of helpful hints and tips and practical guidance. So feel free to dip into that, and our M&R Construction and Engineering LinkedIn group. So thank you very much for joining us today. If you'd like to contact any of us, I think it's on the final slide. You may have our there it is, our details and our QR code. Thanks to our speakers, Patrick and Ed, and we wish you all a very good evening. Goodbye.